things off with the webinar today, The Many Faces of SMSF Property Development. So welcome along. You'll see I'm running solo today, so I have the glasses on just in case I need to read any wonderful questions that come throughout the presentation. By all means, if you have any questions, don't hesitate to ask. I look forward to conversing along the many elements in regards to property development. So what I wanted to I guess start with today and start to talk about from a concept point of view is that self-managed super funds and property development is certainly a key issue, and I guess straight off the bat, and when I'm talking about my glasses and presentations, the many faces of SMSF property development is an interesting, I guess, subject matter, because clearly what I was ultimately identifying was the many facets of SMSF property development, but I put it down as faces, left my T out, and ran with it. So whilst we are going to talk about the many elements, let's be clear that there are various faces and things to contemplate in this SMSF property development space. So, as usual, my standard disclaimer about everything contained within the presentation, but clearly here what we're talking about today is more about the legislative elements and things associated in and around property development. So, what are we going to learn, or what are we going to talk about today, and what do I hope you get out of it? So I guess the main thing is many of you would be aware through your own clients or just other learnings about the legislative elements associated with property development inside a self-managed superannuation fund. But I think what we get, or where we're at, given the tax officer's position on this, and I guess the evolution of property development in a self-managed super fund, is this space is always evolving, and we're always seeing I guess legislative amendments, legislative upgrades, and issues that we need to take into consideration. And certainly, when I first started talking about property development from a presentation point of view, the areas that I identified at that point compared to the areas that we need to contemplate now has certainly expanded. And I think certainly the first property development that I was ever involved in from an SMSF and an advice point of view, not giving the advice, but at least undertaking or understanding the legal advice provided, was probably a good 20 years ago now. And so, it's not something new, property development. What we're seeing is that I call it a little bit of the rule of Tim, and it's based on how many questions am I getting from our client managers, but also if I'm going to present at any form of seminar or session, and in whether it be the tea break, the drinks afterwards, or just in general conversation, the number of questions I get about specific sort of areas sort of dictates to me where the interest point lays within the industry at any given point in time. And I find that in the last few years, with a slightly lower yield, that people are looking at what options have they got with reference to generating returns inside their super fund. And of course, whenever we get these sorts of concepts, then the first place that people often look is property. And so property development certainly becomes one of those much asked questions that come my way throughout any sort of, I guess, investment sort of market fluctuation thing. So the things that we want to look at today is those key legislative provisions, understanding and acknowledging the related parties associated with property development, who's involved in the transaction. And let's appreciate as we go through this that most instances we will be dealing with related parties as such, but there will be circumstances where there are other parties associated with the property development, and then it's clearly a position of identifying who's responsible, how's the investment structured, what are the returns, who's entitled to what, and all the key issues associated with it. And then we're going to distinguish a little bit between the transactions that are allowable from those that are not. So again, that really fits in with that whole key legislative provision element from a transactional point of view. So I thought I'd start with what we've received from the tax office in this space, and the key thing that we obtained is this SMSF regulatory bulletin from 2020, which is 2021, and it's self-managed super funds and property development. Now, this is a key issue. In this presentation, I first put it together in the sense of for presenting to the broader community. I put it together at the SMSF Association conference in March 2020, and so it would have been in February 2020, which would have meant that my life would have been a lot easier at that time had this bulletin have come out a month prior to its actual release. And so, what it effectively has done is it's really solidified in my mind all the key issues that I felt were necessary to talk about in regards to property development and highlight those key issues. But what I sort of highlight, or what I like to see from this ruling, and I'll reference it a couple of times throughout the presentation, is one of the very early statements that the tax office make, and I think you'll see it actually there on the slide there at paragraph 3, is property development can be a legitimate investment for SMSFs, and the Commissioner does not have any concerns with SMSFs investing in property development. So if I put on my my pop culture hat just for a moment, I'm a fan of Game of Thrones. And I remember in one of the final episodes, don't judge me on the final series, but they talked about Ned Stark and saying that anything that comes before the word "but" is often considered horse. And I won't continue on with the rest of the statement. And that's what I found interesting about this ruling. It was like the Commissioner says there's no problems with property development, however, and I think however is the legislative reference to but here, as far as, okay, well, the Commissioner says there's nothing wrong with it, but there's plenty wrong with it. And so it's a matter of identifying that if your clients go down a path of property development, it's not just something to be jumping into. It's something that they need to have thought out well in advance. Clearly, I suspect that there's a greater need for, whether it be SMSF specific advice or at least some form of legal advice, then that's an appropriate path to go. Albeit that as I finish up today, I'll reference some material from the ATO website, and they're talking about a client who went out and obtained legal advice, and that legal advice would have been quite damaging to the fund from a compliance point of view. So I think there's a matter of identifying that there's more to it than just getting one party signing off on the transaction being acceptable. So what I call the legislative hurdles to this, and I've put it there as Tim versus the commish. So it was not meant to be combative. That's the versus there is not combative. It's more Tim's position versus the Commissioner of Tax position once they release the ruling. So this is really more how much we support and agree with each other, and very complementary to each of our own thinking. So what I've identified here, and these points are reiterated largely through the SMSF ruling, is that there are key legislative issues that we need to overcome with regards to property transactions. So there's your old faithfuls, obviously the sole purpose test, and everything we know at the end of the day comes back to the sole purpose test. And whilst I don't want to spend too much time talking about other sort of non-property development based transactions, there's this real link in a couple of cases recently where the tax office have taken action against self-managed superannuation funds, or more potentially the related entities that have transferred investments to the self-managed super fund, because the objective of the transaction has been deemed to be to provide a tax advantage to that other entity. And so, the directive from the ATO is, well, that's a breach of the sole purpose test. And so I think the concept of property development, as I'll highlight throughout, is this transaction being undertaken to solely provide for the retirement benefits of the members of the fund, or is there some sort of underlying benefit being attributable or being received? And of course, that's always a $64,000 question with any SMSF transaction, that you ultimately just need to be able to justify. And I think that as we progress from a regulatory point of view in the SMSF industry, parties like myself have to take a fairly different position, or address things such as the investment strategy very differently to how we did it, say 20 years ago, even 15, maybe even 10 years ago, where the investment strategy as such was largely a compliance tool, which it was nice to have something written, something signed, something you could provide to the auditor. Now, that's a fairly flippant sort of comment, but ultimately that's where a lot of self-managed super fund investment strategies were. We're now seeing, greater emphasis placed on the investment strategy by the regulator, by fund auditors, and so therefore we need to see a greater emphasis placed on it by the SMSF trustees. And so one way of accommodating or at least appeasing the sole purpose test is to have property development, property transactions, anything non-standard, clearly identified and documented inside the fund's investment strategy. Now, that I'm not suggesting that in itself is a way of satisfying the sole purpose test, but at least it identifies that the trustees have given consideration to the transaction in fulfillment of their obligations to satisfy the sole purpose test. And so I think that's a key issue to be mindful of. Obviously, the acquisition of asset from related party rules, always an interesting area in this space, particularly when we're dealing with property transactions and potentially related party builders, but also the transfer of land. And so where do we sit in regards to the transaction if we're trying to bring property into a joint venture or some other form of transaction from a property development point of view that's owned by a related party? So that whole section 66 also underlies this, but from many and multiple angles. Section 65, financial assistance to members or relative. Again, I put that right up there all the time with sole purpose test. I think the two of those transactions or two of those legislative references sit together with the underlying issue of what is the purpose of the transaction. Are you financially aiding the members by doing this transaction via the super fund, or is there some way that you are actually funneling money over to the members or their relatives as such? And then of course the borrowing provisions. Now, the ATO in their regulatory bulletin do spend a little bit of time, a little bit of focus on borrowings, and for me that's probably a key issue, not so much directed by limited recourse borrowing arrangements, because I think fundamentally most people do understand that borrowing to improve an asset is a no-go zone. Of course, that won't stop people undertaking it or contemplating it, but ultimately it's been in the legislation now for well over 10 years, and so people need to have that comfort that most people are going to do the right thing in that place. But of course, borrowing can extend further to the point where, even if we're just talking about borrowings or maintaining borrowings in a unit trust or some other method, that we do have issues that we need to contemplate. So I call these four sort of our legislative staples, and green represents that both the Commissioner and myself agree here. Our next area are also, again, in agreement between both parties, but this is where we start to delve into, I guess, the crossover a little bit between tax and superannuation law. And so this is where we need to understand that we're not just talking about the compliance of the fund, we're also talking about the taxation treatment of the superannuation fund. So the ATO do highlight references to GST and who's paying and what are the transactional obligations under a property development. For me, particularly our areas around arm's length transactions, so 109, SIS 109, identifying that the transaction can be no more favourable to the related party. That's clearly been the trigger for a lot of issues in our industry, I think, particularly in line with limited recourse borrowing arrangements. But now, the direct link, whilst it was always there, the direct link to non-arm's length income and non-arm's length expenses, has really been heightened in the last 2.5 years. And I certainly was really sort of adamant that this was one of the presentations I had to deliver on sort of in a sooner rather than later time frame, because the whole non-arm's length expenditure issue, it just has the capacity, I think, to blow up in the industry's face. And we're focusing a lot of it from a non-arm's length expenditure point of view around accounting fees and those sorts of transactions that have this nexus to the entire income of the fund. And of course, we've got some leeway from the Commissioner in that regard. But these non-arm's length expenses that effectively the changes came in from 1 July 2018, and I'll come back and talk about it a bit later. This is a key issue because if it's a property transaction, the rules are pretty clear and are in effect now. And so there's really no protection from the Commissioner if funds are not paying non-arm's length expenditure on related party investments or non-arm's length transactions linked to property development. And that, of course, has huge ramifications on capital gains tax, but also potentially rental incomes and that in the future. So I think there are areas that we need to certainly be mindful of as we move forward. And probably a couple of other areas, one a little quirky, one not so quirky. Obviously, our regulatory issues, our trustee covenants that lead to the investment strategy, that lead to market valuations, separation of assets. So the key issues around the administration of a self-managed superannuation fund and what we're needing to undertake and practice in as far as ensuring that the assets are valued at market value, to ensure that we're keeping the assets of the super fund separate from our personal assets. Those sorts of areas are pretty critical. And then the other one that the Commissioner introduced and I addressed it probably slightly differently, which is in reference to the transfer balance cap versus total superannuation balance. And again, it's not a versus in any sort of negative connotation there. It's more about identifying that if we go back and look at the valuation issues and those sorts of separation of asset points, or but more largely the valuation, are we ensuring that the fund is treating their assets at market value, are accounting for everything, and what impact does that have on a member's total superannuation balance? Because if there's undervaluing of transactions, are people then able to place more money in the retirement phase and be entitled to the exempt current pension income? Now, I've been talking a lot about property in recent times, and it comes to the point where we have to be identifying in this space whether property transactions and retirement incomes can go hand in hand. Now, clearly there is rental income and the capacity to generate and pay a pension from a fund holding property, but we do have liquidity issues, and we've therefore got estate planning issues as far as ultimately the capacity to sell down and pay out that investment. But also you've got the other liquidity issues if you link it back to an event like COVID-19, which of course we haven't necessarily seen the end of, but we've seen probably the worst of the financial ramifications of that in the second quarter of last year, where there was lots of rent deferrals and rent waivers and things like that, and what impact are those property transactions having on a self-managed super fund. So even though we talk about, and the Commissioner talks about, total super balance and transfer balance cap as effectively a touch point in the regulatory bulletin, for me, it's one of those areas that we do need to understand that when there's borrowings involved, when there's assets that are subject to manipulation from a valuation point of view, we need to be on our game to ensure that trustees are doing the right thing. So they're the key sort of issues there. Then my next group are effectively our in-house asset rules, and clearly we've got our regulation 1322C, division 133A, our ungeared unit trusts and companies, and what they mean for self-managed super funds, being that they are an exemption to the in-house asset, or an exception to the in-house asset rules. Our Part 8 associates, so who are we investing via, and what are the ramifications of the parties to the transaction, and of course then obviously the whole link to the in-house asset rules, our 5% restriction, what that means from a transactional point of view. Because again, if we touch on 1322C and the 1322D requirements, where we've got issues of carrying on a business and other elements like that, well then if we're triggering something that we think is exempt from the in-house assets and we're pushing it into the in-house asset regime, then we're going to be in some form of world of pain where we have to try and unwind those transactions within that effectively that 12-month window following the financial year in which the breach has occurred, or we haven't put the plan in place. So they're the sorts of things that we need to be mindful of. So for me, then red represents the areas that the Commissioner didn't necessarily directly attribute within the ruling, but I've kind of always taken a keen interest in, because I think they have various links to some of the other issues associated with the with the material highlighted in green there. So of course you've got your Reg 1314, which talks about placing a charge over the asset. So that's intrinsically linked to all of our borrowing provisions to some extent, but also it's linked to our in-house asset rules as well, because there's restrictions under 1322C that we can't place a charge over the assets of the unit trust. And so you've got those critical items to identify that if someone's looking at property development as a broad transaction, that they need to be mindful that really, if it's in a related sense, it needs to be cashed up appropriately to be able to undertake the entirety of the transaction. The contribution caps, look, again, this is the whole funding concept. If we can't fund it via a borrowing arrangement, and presumably we can't, or as highlighted by the tax office, we're very much restricted from a lending point of view if we were to try and borrow to buy units in a unit trust that then subsequently does the property development, forgetting the other issues associated with that. Are you in breach of the lending? Because if it's a related party loan, there's no safe harbor, so you have to benchmark that loan against commercial lending opportunities, and will a commercial lender lend money to a fund to invest in units in a unit trust? The short answer to that is no, but of course the opportunity is you have to go out and investigate and find whether or not somebody is willing to provide that money. So the caps then become relevant because we're looking at how we fund money into superannuation. So, where does the bring forward rules fit into this? Where does therefore the transfer balance cap and moving into 1.7 million category and 1.48 at the lower end of the bring forward rules? So what ability do we have to make contributions? What ability do we have to potentially, for the smaller balance funds, use our carry forward concessional contributions? How do all of those sorts of things interact? Is there capacity to use small business rollover CGT relief and use the retirement exemption to contribute $500,000? Of course, you've also got the 15-year exemption, which is in contemplation of retirement. And again, I come back to that whole point: is undertaking property development at the point of retirement an appropriate investment strategy for the fund, given its liquidity needs and other issues? So all of those sorts of things have to form part of the bigger and broader conversation that we're having. And I think 17B is clearly a key issue that we need to link to our non-arm's length expenditure and non-arm's length income area around remunerating trustees for their services that they're providing in a capacity other than the capacity as trustee of the fund. I've spent a lot of time and somewhat effort debating this issue with many parties with reference to what we've received previously from the Commissioner versus what we've got now in the non-arm's length income area. And if the ATO, and I suspect we'll find out sooner rather than later, but if the ATO are going to take a hard line towards non-arm's length expenditure, and there's every reason to suggest that they will, based on that LCR that they release, then a lot of our historical rulings that we've received with reference to what is a contribution and acquiring an asset from a related party and subsequently, the difference between a service and an asset, and therefore paying for that service, all of those areas are going to funnel into the gnarly area and become a bit of an issue for us to contemplate. So they were the key issues. And then the last one that the Commissioner raised that wasn't on my radar previously, but it's very much linked to in one way to Section 65 and financial assistance, but they talk about the payment standards and whether or not there is money funneling out of the super fund to pay a related party who's undertaken certain services on behalf of the fund or a joint venture or some other transaction, and where does that sit in the scheme of things? And I think that all of these things, when they weigh up or are placed alongside each other, identify that property development is a fairly significant issue to be contemplating with reference to a fund, and we need to think through the likelihood of whether or not that transaction works or doesn't work. And so, what I'm highlighting here is I'm going to go through these considerations and talk about at length or to a degree the carrying on of business stuff and then the related party transaction elements, and then finish off by working through a few of the 1322C issues as far as properties are concerned. So I guess the key trigger that we always start with in this concept of property development is, does it constitute carrying on a business in a self-managed superannuation fund? And I think what we have to identify again is that the ATO have at no point said that a fund cannot carry on a business. However, we have to look at the trust deed for the fund, we have to look at the investment strategy for the fund, and we have to look at a whole heap of other things associated with the transactions of carrying on a business inside a self-managed superannuation fund, namely sole purpose test and other things, to see whether or not it is an appropriate transaction for the fund. Now, if any transaction is going to satisfy that carrying on a business requirement, in my mindset, it is that property development style transaction, subject to what the overall objective is for the fund. So to identify that a fund is doing something that is business-like from a transactional point of view tends to lend itself more to property style transactions than any other sort of general operation of a business as such. Nevertheless, we have to be mindful of all the issues associated with it. So what points have the ATO raised historically? Well, they've talked about employing family members. They've talked about any relationship between hobbies and pastimes, and the business is being undertaken, but also that the business has links to associated trading entities. And I think that's a key issue to be mindful of, is that, are people trying to look to move the taxation from one entity to a lower tax entity, being the superannuation fund, and then clearly we have issues that's more so associated with what's going on outside the super environment as much as inside. So those sorts of issues indicate as the fund assets are available for private use as well. So what they're looking at from a tax office point of view is clearly things like the fund investment strategy. Are there any borrowings in place? The financial assistance, all of those points that I've highlighted on the page before. So the whole concept of whether or not we can do property development and whether it's considered carrying on a business, it's more so much about identifying upfront how these transactions are going to be viewed. Because once we determine what we're doing and whether or not it is in contemplation of carrying on a business, then that's going to go some way to determining how we can undertake those transactions as such. Because if we want to say that we want to operate a property development business through the self-managed superannuation fund, then that automatically discounts that capacity for us to do it through an ungeared unit trust or an ungeared company. Because if we've got an ungeared company or trust, then to satisfy the exception to the in-house asset rules, we have to ensure that company or trust is not carrying on a business. So, we've got to do that balancing act of identifying the parties to the transaction as part of identifying how we will structure the transaction. And so that element has to be considered right from the very outset, because otherwise we're going to get ourselves into trouble in that if we go to the expense and go through the process of, say, setting up the unit trust to invest the capital of the self-managed super fund to then undertake the property development, but then we identify this as a carrying on a business transaction, then that's going to lead us to issues later on down the track. And I want to identify a little bit further on in the presentation a couple of cases that were highlighted a few years ago with reference, and they weren't specifically self-managed super funds, but the idea of property development and whether or not something was deemed from a trust point of view to be a revenue-based activity or just a capital-based activity. And I think a lot of it's going to come down to, particularly in the sense of self-managed super funds, it's going to come down to how we transact. And yes, absolutely, just a question coming through whether or not you'll get a copy of the presentation. When I send the CPD points through following today's presentation, you'll have a copy of the materials attached for your benefit. So all of those issues become a key issue to contemplate inside the superannuation fund. But as I said, I'm going to come back and talk about that 1322C issue in a moment. Because of course, what a lot of this is all going to be linked to is whether or not we are dealing with related parties. So in the sense that many self-managed super funds who engage in property development do so because they have ties and links with um, building entities, building licensing, all those sorts of things themselves. It's an area of expertise, and so they are able to work with themselves in other capacities to undertake certain transactions. Now, again, it's a whole different presentation identifying the ways we can buy property directly versus via geared trust, ungeared trust, all those sorts of transactions. But it becomes relevant if we're looking at direct transactions versus via other entities to know whether or not those entities are related entities or not. And for me, these slides that I bring up now, they're slides that I present in a number of presentations about Part 8 associates and relatives, because they are all relevant to the decision-making process that we have to go through from an SMSF point of view. And of course, the key thing for Part 8 associates, particularly with property development, is, are we dealing with a controlled company or a controlled trust? Because if we are, or if we're investing either via them or in conjunction with these other parties in, say, a joint venture, then what sort of is the ramification from an in-house asset rule, a geared or ungeared transaction, all those sorts of elements. But also, the links to joint ventures, being that a joint venture as such is in many ways akin to a pure partnership or a tax partnership. And of course, they need to be structured appropriately to ensure that that they're not just treated as partnerships. Because if you enter into a joint venture with an unrelated party, but it's actually determined that that's a tax partnership, then you've effectively linked yourself to that other party via that joint venture in a partnership, creating a related party transaction and creating all the problems associated with then having those related party transactions. So again, it's one of those key issues that when we're contemplating what to do in the SMSF space, we need to be mindful of who we're transacting with. And if we're transacting with other parties, as is likely to be the case, then where do they sit in the related and unrelated scheme of things? Which of course then we need to understand who is a relative from a related party point of view. And realistically, there's not too many parties in the grand old family tree that don't constitute related parties from a Part 8 associate point of view. We have the former spouse. Now, the likelihood of a SMSF trustee engaging with a former spouse to undertake property development is likely to be minimal. I mean, we're not going to see too many Bill and Melinda Gates types arrangements where they're going to continue on in that private investment capacity, but then separate from a personal relationship point of view. That's not going to be the norm in the SMSF environment. So we need to appreciate that we can cross the former spouse element off there. And then cousins, well, where do we sit with regards to our cousins, and whether there's a likelihood of investing collectively with the cousins just to avoid the related party rules? I suspect that the only memory I have of my cousin is that he was a magician, and that makes him somewhat dubious in my eyes, because magicians bother me, and so I'm not sure that is the appropriate investment or transaction to undertake. So when we're looking at the engagement with anybody else, if there's that link, that relationship there, then we're having to delve into all of the key issues associated with related party transactions. And then what we're doing there with regards to those related party transactions is we're starting to interact in all of the in-house asset provisions, and that is hugely problematic as far as the self-managed super fund is actually concerned. So I think what that really leads us to is probably, to me, what I would consider the crux of the presentation, and the key areas linked with the presentation, which are all around the concept of the arm's length basis transactions, and what that means for self-managed superannuation funds. So we've got the related party issues. So we've clearly got the link to related party, and we go back to the previous slide and identify who all those parties are. And then we just reference the National Tax Liaison Group, or the Superannuation Technical Committee, which was a lot of industry heavyweights working closely with the tax office for a number of years up until 2013, when the committee was disbanded. But in December 2010 and in 2011, there was a great emphasis placed on related party builders, and the idea that related party builders were providing materials to undertake transactions such as property development, but even contemplating such things as repairs and maintenance and other elements of the superannuation fund. And this is where, to me, that we can undertake with all the best intentions a property development from a self-managed superannuation fund point of view and tick the majority of the compliance boxes. But it's then these other areas that now, in light of the NALI provisions, and I'll go there in a moment, in light of all of that, we're so close to tarnishing these transactions with a 45% tax rate that we have to contemplate whether or not it is the appropriate transaction to engage in the super fund, given that in many respects, some of these things will be at the whim of the ATO with regards to how NALI is determined, because the auditors will have an obligation or responsibility from an audit point of view to effectively bring to the trustees' attention, that the tax is calculated via the financial statements based on the assumptions that everything is okay, but given that there's an opportunity or possibility that not everything's okay, then there's going to be this tax arbitrage that's introduced from the ATO if they undertake any form of, I guess, transactional audit. So they start to identify property developments or large property transactions in a self-managed superannuation fund and take issue with it by addressing it. So when we're looking at these arm's length transaction issues, what we're clearly looking at to start with is Section 109 of the SIS Act, which talks about that the transaction can be no more favourable to the related party. So that's always a problem for me, because it means that that if the self-managed super fund engages in any transaction that is favourable to itself, it ticks the compliance box. It ticks the super compliance box to say, if the fund is not paying market rate or the fund is not doing anything and it's favourable to the superannuation fund, then it is not in breach of the SIS Act, and specifically Section 109. Clearly, in that set of circumstances, it's also not providing any sort of financial assistance to members or relatives, because the member or relative are the ones being disadvantaged if they're providing services, materials or whatever, and they're not being remunerated for those materials. Then clearly that is an issue, or not an issue, of financial assistance to the fund. So then we've got to link together the arm's length requirements with this concept of no financial detriment to the self-managed super fund versus our contribution ruling, which was tax ruling 2010 one, and our acquisition of asset from related party, which was SMSF ruling 2010 one, which addresses the inequity between not paying for something from a super fund point of view and ultimately satisfying the SIS arm's length requirements with what it means for the fund, and as far as actually dealing on an arm's length basis and ensuring that all transactions are undertaken from a market linked, or from a market valuation point of view. And that then links us into the NALI provisions as well, which I guess throw the real sort of proverbial cat amongst the pigeons, because what we're now seeing is what we felt was an acceptable approach, and clearly from a property development point of view and property transaction point of view was an approach taken by many self-managed superannuation funds, was historically we took the opinion, or took the position where, okay, if a related party provided the service, right, then we could treat the difference in some sort of way. If it was small in value, we could treat it as a contribution of the superannuation fund. Now under the NALI provisions, we're going to have issues with doing that. So what we have to be able to identify through all of this is that what are the provisions that we're really looking at here, and then where are the catch-all elements to consider. And of course, so SIS 17B talks about remuneration of trustees, and of course that service has to relate to duties or service other than their capacity as trustee. Now, again, generally as a trustee, that is a different set of services to being a builder. So we can delineate or distinguish between those two transactions, that the trustee is appropriately qualified and licensed to perform the duties or service. And again, I'm going to touch on in a moment this case that I referenced in my build up to the presentation, where appropriately qualified and licensed became a bit of an issue. This person wasn't necessarily linked to one of the self-managed super funds, but they had their own self-managed super fund engaged in this transaction as well. And if they were remunerating themselves because they actually had their licenses disqualified, then they wouldn't have satisfied this requirement. And I think they're the sorts of transactions that often get lost in translation. They perform the transaction or the service in the ordinary course of business, and it's no more favourable than an arm's length transaction. So that's what we have to undertake when we're looking at trustee remuneration and whether or not we can remunerate the trustee. If no liability is raised in the fund, so that's if we're going to pay, you've got to meet these conditions. Of course, the legislation doesn't say you have to pay. And so if you don't pay, then it increases the capital of the fund. So a contribution is deemed to be anything that increases the capital of the fund. And so that's where we go back to TR 2010 one, said anything that increases the capital of the fund is going to be treated as a contribution of the fund. Of course, if you're doing that, then depending on what the transaction actually is, if it's considered, say, an acquisition of an asset from a related party and it's for building materials and other things, then we're going to be in breach of Section 66. So it's ultimately the jungle that I'm describing here is all of the things that we have to sort of hack our way through when talking to anybody with reference to property development, that it's not just about can a self-managed super fund develop property, because the short answer to that is yes, it can. It's have you contemplated who are the parties, what sort of remuneration, are there contribution trigger points, are the parties related, are you satisfying 17B? Is anybody that's performing the duties licensed to undertake those duties? All these sorts of things form part of just the starting point for asking questions under this place. So the key considerations are, if we're appropriately qualified and don't charge, is it going to be a contribution? If we're undercharging and it's a contribution, then is it the difference between market rate and the actual amount paid? So what is the position there? And again, these sorts of matters have been addressed by the tax office in a non-arm's length expense world, and we can only take on face value that the non-arm's length expense ruling, which is largely or is a taxation-based ruling, has to take some form of precedence, because what we're actually trying to determine here is what is the point of this transaction being undertaken in a self-managed super fund. And for most, the point is that we're trying to undertake it for the purposes of the better tax environment to provide for a greater retirement income. So if we're not putting NARLI and non-arm's length expenses as the first thing to contemplate, then we're ultimately potentially operating in a 45% tax environment, which is not helping anybody's retirement benefits, because we're paying that sort of tax rate on the outside. So we're needing to be mindful, and we're tarnishing investments all the way along. So, who will determine these sorts of issues? Well, if the trustees aren't determining it, and then the auditors identifying it and bringing it to the attention of the tax office, then there needs to be that justification process at that point in time. So when we're dealing with these transactions, we basically get to the point where overcharging is going to be a breach of 17B, Section 65 and Section 109, but undercharging, which basically gives us the benefit of SIS, but it creates a tax issue. And so ultimately what we need to ensure is that we are finding that sweet spot of commerciality to undertake all transactions from a property point of view. And so I think what we need to be mindful, or most mindful of in this space, and I come back to this law companion ruling that the ATO released on arm's length requirements and non-arm's length expenses. And yes, we've just recently got a further extension of the effectively nothing to see here approach from the ATO under PCG 2025. But what the ATO are really identifying and saying, when we're talking about income linked to general administration expenses of the fund, where there's that nexus to all of the income, then you've got effectively commissioners' discretion that they won't be undertaking any compliance activity. What this doesn't provide is any form of discretion around non-arm's length expenditure if you're dealing in property transactions or anything else where you're not dealing at arm's length, and the entity, as it says there, incurs a loss outgoing expenditure that's less than market value, including nil. And of course, by extension, it's whether you're doing it directly or via as the beneficiary of a fixed trust. So you've effectively got this scenario now because of this ruling and the legislation that was introduced from 1 July 2018, that absolutely every expense of the super fund needs to be not only paid by the superannuation fund, but it also needs to be commercial. And it needs to obviously be in the future the best financial interest of the fund as well. So not only do we need to contemplate the rules as they currently stand, we also have to look at what the rules of the future are, with best financial duty coming in as part of the Your Super, Your Future regime that was announced last year. So all of these things really trigger a great deal more to consider when we're contemplating property development. So I guess my message from that with regards to the fund is whether we're engaging with related parties or not, we need to be mindful of ensuring that we are paying a commercial rate and not going back to the days which many of us have experienced, and that is self-managed super fund trustees being very comfortable that they are undertaking transaction with a related party, undervaluing their own service by effectively not paying for that service. So yes, buying the materials potentially, but not charging a labour fee. We have to be pretty strong now with trustees that are going down this path to make sure they do the right thing. And so when we're talking about undertaking a property development and self-managed super fund, it's what is being contributed. So what's the super fund's contribution to it? Is it contributing 100%, and is it doing it directly? And if it's doing it directly, if it's engaging with unrelated parties, then you've clearly got yourself probably a pretty clean transaction for the SMSF to undertake. If we then say, okay, well, it's going to do it directly, but it's going to do it directly and utilize related parties, then what contract provisions have we got in place to ensure that that potentially a contract is being entered into where the related party is acting as an agent for the self-managed superannuation fund? Are they then charging commercial rates for all of the transactions? Are they accommodating, or are they accounting for every expense? And is every expense being paid for out of the super fund bank account? Because whilst we see these transactions a lot of times occurring where the members will pay and then the super fund will reimburse, I bring you back to the payment standards and the fact that the ATO highlight that, and they highlight it in the regulatory bulletin, where that gives rise to effectively accessing preserved benefits and paying the member out if that transaction is not a void or valid transaction. So we just need to make sure that we're pretty clear that all transactions in that sense would need to be funded by the super fund directly. And so then if you go the further extent and talk about related party investments or investing through a related entity, and we'll use the trust as the example, then meeting the 1322C conditions, and I'll talk a little bit about those in a moment. And then you go probably to the third extension of these transactions, which is a self-managed super fund engaging or investing via an unrelated entity, and that unrelated entity undertaking property development, and then a super fund being distributed proceeds based on their investment in that unrelated entity. Now, from a cleanliness point of view, that third option, the unrelated entity, is probably as clean as the direct investment and engaging unrelated parties, because there's no ties to any related parties inside that unrelated trust, albeit that a lot of funds will push the boundaries of related and unrelated trusts and invest in a 50-50 basis. And then we start to talk about control, and I think control becomes a big issue in this space that we need to be mindful of. So when we start to talk about all these things, we can link them in to sole purpose test, borrowing provisions, trading trust, and all those sorts of other areas as well. And the thing around the concept of the trading trust ultimately is if a trust is deemed to be considered a trading trust, then we're paying 30 cents in the dollar rather than the 15% super tax, but we get that effectively back through the tax distribution sort of franking credits type arrangement. But putting that aside, or putting that secondary to the transaction, if we look at developing these transactions through a unit trust, then we do need to understand whether or not the trust is carrying on a business. Now, there are a couple of good examples from 2015 and 2016, WWXY and FLZY. So I'm not sure what was going on back in 15, 16, where we were just naming everybody after elements of the alphabet or whatever it was necessarily there. But in the first instance, the WWXY fund, they actually undertook the acquisition of a fairly significant property, and they had put in plans to develop that property and had sought council approval to develop that property. But then that approval and the plans fell through, and they ended up just selling the investment. And it was determined in that instance that it was their intention to develop that suggested that they were carrying on a business, and so the sale was of a revenue nature. And of course, that then would suggest that if we're investing via 1322C, that we're in breach of the carrying on a business provision. FLZY came back and identified similar style arrangement, but they had acquired the properties with a view of leasing the properties, so generating revenue, and then after doing that, felt the desire or the need to undertake development of those properties to enhance the income or the revenue generating capacity of those properties. Now, in that instance, they looked at the intention and said, the intention here is to buy to generate income, and therefore, so it wasn't effectively a buy and flip type approach. It was buy and hold with the leasing point of view, and then developing as part of the ongoing process. So it's all going to come down to, again, looking at the investment strategy, looking at the original transaction to ensure that the fund is doing the right things. And so I think those points sort of highlight that relatively clearly for us, that it's, again, coming down to an intention based approach. And the ATO, I guess, reiterate this in their ruling, and they say, and this is a direct quote, while it's common to see self-managed super funds make use of ungear-related companies or unit trusts for the purposes of property development investments, SMSF trustees need to consider how they're going to meet and maintain the conditions set out in the legislation. So, the ATO almost, given the timing of this ruling, is post those two cases that, as I said, weren't necessarily SMSF specific cases. There is this requirement that you need to be aware of and maintain your compliance approach the whole way through the transaction. So if you are initially entering into a transaction to do property development to flip properties, then clearly doing it through a related unit trust is going to be problematic, because it may be more akin to operating a business, and that is going to be an issue for the fund. Whereas if you are buying a property inside a unit trust with a hold strategy to lease it, you then undertake a development of that property. That's a very different transaction and needs to be identified from the outset. So I think it's really, for me, just a matter of ensuring or identifying these key issues. And so that leads me to where I want to head towards the finishing line over the next few minutes. But I want to raise this case and link it up to joint ventures. And some of you may have heard me talking about this one before, and I think it sort of rang true because when I first read it, of course, being an Adelaide case, it always sort of rings a bit closer to home, and you get a bit of an appreciation for it. But when I looked at it and I look at the final outcome of it, I look at it and think, well, maybe there were better ways of doing it. Certainly not entering into a transaction with Mr. Zollo would have been a good way of entering the transaction, or identifying the transaction, or cleaning it up. But I think that the concept of what this self-managed super fund was trying to achieve was relatively satisfactory. It's just there was a whole chain of events that determined that it was problematic. And again, it comes back to the concept of the joint venture, and what came out of this court case was under the joint venture that there was this fiduciary duty of the other party to the transaction to make or not make false declarations, and to identify any potential issues associated with the transaction all along. But to summarise it in effect, so you had Neil Polly, who was trustee of a self-managed superannuation fund, and he was in effect the money man. And then you had Alessandro Zollo, who was effectively the builder, or the building expert. Now, the issue is that, as we'll come to see on the next slide, Mr. Zollo wasn't necessarily or at least from a licensing point of view, the expert that he portrayed himself to be, and that created an ongoing impact and effect for the transactions of the fund. But what they did was they engaged in this transaction via this company that they set up, which was SA Disability Housing Proprietary Limited. So they identified an area of the market where there was opportunity to invest, and that was disability housing. And Mr. Polly was pretty keen, being suffering from a disability himself, very keen to use it as an opportunity to provide housing for a particular part of the market and generate revenue for the super fund. So they did establish this SA Disability Housing business. The issue was Mr. Zollo was disqualified, and had been for many years from a building point of view, so that was never disclosed up front. The other thing is SA Housing Proprietary Limited, Mr. Polly was the only director because Mr. Zollo was disqualified from being a director. So there's a whole number of issues linked with the transaction, but the super fund was the provider of the money, and the key issue, I guess, in this transaction was that you had this company set up to undertake it all, but the assets and the property that money from the super fund came for was actually used to acquire property that was then subsequently transferred in some instances to the trustee of the self-managed super fund, not to the Disability Housing Proprietary Limited. And so it clearly identified a lot of key issues where, firstly, know who you're dealing with, but they could have effectively established a 50-50 company to start with that would not have been related, or potentially wasn't related if there was no control on either side of it all. They could have then determined that the distributions were based on that 50-50 investment, and then they could have ensured that all the properties were acquired via and held in that company, and they could have done property development. So there's no real issue necessarily with that from an overall transaction point of view. But the way they went about it, by setting it up and calling it a joint venture, it created this issue of assets being incorrectly titled, distributions and revenues not being collected sort of on an agreed basis. And so the point really came down to, okay, we need to make sure that we are addressing these issues appropriately and satisfying the requirements of the super fund first, before determining how to structure the transaction to get the outcome that we want to achieve from what the objective is. And in Mr. Polly's objective was to invest in residential property that could be then leased out within the disability sector and generate revenue for the fund. So very appropriate, and to have that all listed in part of the investment strategy. But then it came unstuck because of the parties that he necessarily engaged with. Now, of course, had they have just done it as Polly and Zollo and not incorporated the company, then they would have triggered a partnership and they would have had in-house asset issues as well. So a number of things for them to be mindful of. So look, to finish off with, I guess what I wanted to identify is that this page on the ATO, they've got their Super Scheme Smart page, and it goes through a lot of what they consider retirement strategies and issues to be mindful of in the scheme of self-managed superannuation funds. And the example of Tom and Leanne is a good one, which I think in many respects summarises what I've been talking about today, probably more succinctly than myself. But what it identifies is that Tom and Leanne went out and got legal advice on taking the property they owned in their company and using the proceeds from their super fund to set up a trust and do a joint venture to generate income that was then going to be distributed on a 50-50 basis, albeit that the super fund contributed $300,000 and the company $1 million property. And it talked a lot through the non-arm's length issues and things associated with that. So I kind of highlight that scheme as a way of summarising and a reference point for you to go and have a look at, and probably is a good starting point that if you've got clients in this space, rather than going down the SMSF advice piece first, rather than getting them to go and look at the broader internet to see where their transactions sit, is to see what material the tax office already have available. And to use that material to their advantage to determine whether or not they should take the next step, which is to seek out the appropriate advice. In this super smart scheme, Tom and Leanne, they took the advice, and then they, having spoken to their accountant and their auditor, they made the decision not to proceed in the self-managed super fund. So they did make the smart decision, but there were parts of the transaction that could most certainly have worked had they've got their structure right in the first. This was, for me, it was an opportunity to say property development is an area that we're getting questions about a lot in a market time where there's a little bit more market volatility. And whilst we're seeing sort of changes in that space, it's an area that won't necessarily disappear. And so it's not about having all the answers up front. It's about having the capacity to direct trustees down the right path and to ensure that they are seeking the appropriate advice and looking for the appropriate structure based on their set of circumstances. So that brings us to the end. As I said before, I will send a copy of the presentation through with the CPD. If anybody's got any questions, please put them in the chat box.